I've got Kenneth Harker here. Good afternoon, Mr. Harker.
Good afternoon, Your Honor.
I've got Gary Feynman here. Are you here on the Fannie Mae case?
No, I'm here on the 1-800 Hanson's LLC. Mr. Harker's the defendant.
Oh, yeah, that's the 145 case. So let me get that. Switch from landlord tenant to general civil for a minute. Mr. Feynman, what's your P number?
Good afternoon, Your Honor. P41-655.
We were here earlier on June 26th. Matthew Kuipers was here for the plaintiff at that time. Mr. Harker was here. The parties were put into a breakout room to discuss things. 1-8 Hanson's was hired to install some gutters and do some other work at the defendant's house. The defendant was dissatisfied and contended that they didn't provide the product they said they were going to. And they gave a credit of, I think, $513. The company, 1-800 Hanson's, is now suing for $4,655.00. We did discuss the matter, and we had settlement discussions on June 26th, but the matter was continued for the summary disposition motion here today. And here we are. Has there been any further discussion?
Well, Your Honor, I'm just covering this matter today. You can ask Mr. Harker if there has been.
Yeah, that's always a problem. He discussed it at some length with Mr. Kuipers, and then somebody else comes in from that doesn't have the background. Are you with Velo Law Office, or you're just covering
No, I'm not. I was asked to cover this hearing.
Yeah, the rules changed, and people were supposed to provide an appearance for a temporary assignment, but then when COVID hit, it all just fell apart. So I get people to show up. I have no idea where they're from, what your address is, what your phone number is, whether you're with a firm or not, and you don't have any background information. So, Mr. Harker, what's your position?
Well, Your Honor, I'm going to start from the beginning. Hanson sent a salesman to my home.
Well, listen, I don't have time to start at the beginning, at least not right this minute. They filed a motion for summary disposition. Do you know what that is?
No, not totally. I'm not a lawyer.
No, that's common. Lay people are very unfamiliar with the concept. They did file a brief and pleadings, and so I'll ask Mr. Feynman to speak to that first. He contends that there are material issue of fact. What's your position with that, Mr. Feynman?
There are no material issues of fact, Your Honor. As you know, this was a contract to install gutters. Defendant's answer, he admits entering into the agreement, but he states that it was a different gutter grade system that was installed. I think that's what the essence of the issue, but my understanding is the plaintiff was unable to install the gutter grades requested, so they were substituted for a product of similar quality, and that's per paragraph 1 of the terms and conditions of the agreement. The operative language is contractor or its manufacturer may at its sole option upgrade a product to similar or higher quality. And then as you referenced, Your Honor, the plaintiff did credit the defendant $513 for the substituted product. And also procedurally, defendant listed no affirmative defenses to their answer. Plaintiff mailed defendant requests for admissions on or about April 18th, 2023. Plaintiff has failed to respond to those. I don't need to cite the case law that says that if you don't answer, they're deemed admitted. So for all those reasons, Your Honor, there's no issue of material fact. Plaintiff is entitled to judgment as a matter of law pursuant to MCR 2.116C9 and 2.116C10. And we would request that an order be entered granting the motion.
All right. Now, Mr. Harker, what do you want to tell me?
Okay, the salesman should have known when he came and looked at my place that the gutter grate system couldn't be installed with my steel roof. Never said a word about it. And I was never notified before installation that they were changing from a gutter grate system to a gutter RX system. And the gutter RX system is not an upgrade. The gutter grate system had a 100% clog-free guarantee with it. The gutter RX system had a flat aluminum that sat down inside the gutter, 3/4 of an inch or so. That is not a gutter protection as far as I'm concerned, because all it did is fill up faster. And there's a picture, exhibit 2 in the paperwork that my lawyer sent. And it explains that it's sole option to upgrade. It is not an upgrade in any means. Now, if they had told me they were changing from the gutter grate to the RX system, I would have said, no, I don't want any of your stuff. And I told them to come get it because I didn't want it. And they refused to come get it. So I offered them what I thought was a fair price, because the outfit that put my my gutter protection on, a good gutter protection, they would have installed me gutters for in the neighborhood of $1,200. So I think I'm being way overcharged for their gutters.
Well, that's not a defense. We talked about that last time.
Well,
You
I know
signed
that.
this contract.
I know
And
that.
so if you go out later and find out you could have found the product cheaper. Now, did Hanson's actually install the gutters?
Yeah, they installed them, but they never told me that they were putting
All
up
right, so you believe you don't owe them anything? You just get to keep them and they don't pay anything?
No, I offered them what I thought was a fair price for the gutter.
Well, are you an expert in
they
home
can-
construction where you just decide what a fair price for this is?
Well, do they get to just decide what a fair price is?
Well, they have a contract that you signed and initialed in about 25 different places. 1-800-Hanson's didn't just show up one day and decide to go into this business. They've got a contract. He also mentioned something that kind of went over your head. They sent you a request for information, and you didn't respond to it. When you don't respond to it, everything in there is assumed to be correct as they allege. So they filed a discovery request and you didn't answer it. So the motion for summary disposition is a motion that says the defendant has not stated a defense and there is no material issue of fact. That's what their contentions are. That's 2.116C9 and C10. Mr. Felt helped you file this original answer, but then things have happened since you filed the answer.
And I didn't understand that part of it.
I'm sorry, go ahead.
I say I didn't understand that part of it.
Well, I know when you're at a disadvantage, they've got a lawyer and you don't. And there's certain court rules that apply to this, and you haven't complied with the court rule. And this motion for summary disposition, I deal with this a lot. Regular people don't understand it. In fact, a lot of lawyers don't understand it. But 2.116C9 and C10 are both very common. The most common reasons people seek to enforce a summary disposition motion.
Okay,
Uh,
can I ask something else here?
Yes,
It states right here in the agreement, it says this agreement cannot be changed by any conversations between owner and contractor. Any changes must be in writing and
what
signed.
clause are you in?
I'm in the same, it's exhibit 2. It's the
Yeah,
same one,
what paragraph?
paragraph 1.
All right.
And that's where it goes on to say any changes must be in writing and signed by owner and contractor. Contractor or its manufacturer may at its sole option upgrade to a product, which that was not an upgrade. Similar or higher quality.
Yeah, the problem is this is cut off. So the copy that I have, it starts on page 1 and goes to page 2, and some of the important language is missing.
See, that's my whole point with this whole thing here is they never let me know they were changing anything. They just came and did it, threw it up, and then said, and then they never told me even after they installed it. I had to get up there with a ladder and find out that they had changed it. Otherwise, they would have charged me the full price.
Well, they gave you a credit, but it says unused materials. So I'm not sure what that is.
Well, they claimed that was a difference in cost between the two. So if it's an upgrade, then why does it cost less than the better one? It's all, there's no upgrade whatsoever to it. And if they had let me know before they installed they were changing it, I would have said, no, I don't want any of it. They never gave me the choice to back out on it. They just went ahead and put up what they wanted to put up. And it's that I got a picture in exhibits here too that shows it was less than a month, and it was completely clogged full of junk. That is not 100%. It's exhibit 6. You can see how well it works. I might as well not had anything in the gutter. It might as well just been open, and that's not what I wanted. The whole reason that I ordered the thing from them is because they had the 100% clog-free guarantee. That's the kind of stuff that I wanted. Now they're forcing me to pay their outlandish price on just gutters, and I don't want just gutters.
Your Honor, as you mentioned, improper defendants are subject to the same court rules as everybody else. There was no response to this motion, no response to the request for admissions. He can't just keep this for free. He got the gutters. He signed an agreement. There is a clause that says they can provide a product of similar or higher quality, and he got a $513 credit for that. And there's really no issue here, Your Honor. This motion ought to be granted for all the reasons you stated and for the reasons I stated.
Well, it sounds like he did not get what he wanted, but you're right. We're not in small claims court, Mr. Harker. We're in general civil court, and the rules of procedure and evidence apply. And you didn't comply with either of those. They filed this motion. You didn't make any response. They requested a production of documents or information for admissions, and you didn't respond to that. So those admissions are accepted as true. So I don't have to like this. I don't think you got what you contracted for. I think you paid a very high price for it. I don't think it works. And you can certainly appeal this, but the same rules apply as if you had an attorney. And because of the fail to answer the request for admissions, there is no material issue of fact. And you failed to state a defense. You can review this with Mr. Felt, but I don't have to like this. In fact, I don't like it, but I have to follow the law. I find summary disposition for the plaintiff. Defendants that are unrepresented in general civil cases against big corporations often end up on the short end of the stick. There was settlement discussion that went nowhere. You decided to pay them what you thought was fair. I don't know how that was determined. I don't know. They did have lengthy discussion to settle it, which failed. Now I heard this motion. You owe them $4,655, $154.41 in costs, and a $75 statutory attorney fee, for a total of $4,484.41.
No, it's $4,884.
4,884. I couldn't see it. The print's so small. 4,88441.
Your Honor, will the
This is
court be
the-
preparing that order, or would you like?
There
counsel
is an
presence?
order here, and I'm
Oh, good.
signing it.
Okay.
This is not a rousing advertisement for 1-800 Hanson's.
And the
But
court
I
will mail
find
that
it-
out to the parties, Your Honor?
Yes. Mr. Harker, I suggest you might want to share that with Mr. Felt. He can watch this proceeding on YouTube if he wishes to, but I find on their behalf, I don't have to like it. All right, that completes this matter.
Thank you, Your Honor.
Thank you, Your Honor.